Hello, everyone, and welcome to the next edition of the Employment Insights Podcast 2024. My name is Rebecca Kearney, and I'm a Principal Associate in the Employment team based in Liverpool. I'm joined again today by my colleague Mark Landon, who is a partner based in our London office. Hello, Mark, and thank you for joining us today.
That's a pleasure. That's a pleasure.
So today we're going to do a quick roundup of some of the employment law changes that have come in recently at the beginning of April, specifically focusing on those family-friendly changes that have come in. So what topics are we going to be covering today, please, Mark?
Okay, I think 4 topics linked to working families. The first is the extension of protection in a redundancy situation, or if you like, preferential treatment in a redundancy situation for women who are pregnant or where there's been an adoption, or in some cases where there's been shared parental leave. I'm then going to talk about the changes to the paternity leave rights. Then I'm going to look at the introduction of carers leave. And then finally, I'll just have a quick recap of the changes to the right to request flexible working. And all of those came in on the 6th of April this year.
So there's been a lot going on.
Yeah, no, there has. And you know, as always, I think some of this slips under the radar because it's flagged up a long time ahead. And then I think sometimes people lose sight of the actual date when it becomes law. So if I start with redundancy protection, prior to the 6th of April, if a woman on maternity leave found herself at risk of redundancy, so say she was in a pool of employees who were at risk of redundancy, we know that unfair dismissal law requires that the employer should look at offering suitable alternative employment to at-risk people to avoid them being made redundant. And what the maternity provision said was that if, for example, you had 20 employees at risk of redundancy and you had 3 vacant roles which could be offered to 3 out of the 20, if any of those 20 were actually on maternity leave at the moment, that person should be offered one of the vacant roles in priority to the other 19 people in the pool at risk of redundancy. So, provided it was a suitable alternative role, a woman on maternity leave would get preferential treatment as regards being offered that vacant role. Now, what happened on the 6th of April is that this protection was extended so that in the case of a woman who has a baby, she now gets that preferential treatment throughout the period of her pregnancy and for 18 months from the date of birth. So if you think about it, under the old regime, the maximum maternity leave you could have was 52 weeks. So the maximum preferential treatment you could get was for a 52-week period. Whereas now, as of the 6th of April, a woman at risk of redundancy who is pregnant should get that prioritization with regard to a vacant role. And also, she should continue to enjoy that preferential treatment for 18 months from the date of birth. So whereas before the maximum period of protection was 52 weeks, it's now 9 months pregnancy and 18 months. So both while you're off on maternity leave and effectively for 6 months after you return to work. Now, also, that protection has been extended to women who adopt a child. And the way it works is that that period of protection, that prioritization, is for 18 months from the date of adoption. And also, for those taking 6 or more consecutive weeks of shared parental leave, but who have not taken maternity or adoption leave, they get this 18-month protection again from the date of placement of the child for adoption or the child's birth. So what you've got is a much longer period of protection and also being extended to those who are adopting and in certain circumstances, those who are on shared parental leave. Moving on to paternity leave, Prior to the 6th of April, you were entitled to 1 or 2 weeks paternity leave that you had to take within one block. You couldn't split those up. And you had to take the paternity leave within 8 weeks of the birth of the child. As of the 6th of April, you can split up those 2 weeks. So you can take 1 week and then separately another week. And you now have a year from the date of the birth rather than 8 weeks in which to take the paternity leave. We've also had the introduction of a new form of leave, which is carers leave. So as from the 6th of April, somebody who is looking after a dependent person will be entitled every year to 5 days unpaid leave. And you can take that as a block of 5 days, as a half day, as single days, however you want to do it. Essentially a dependent for the purposes of carers leave will be someone who is a spouse, civil partner, child or parent of the employee, someone who lives in the same household as the employee, but not if they are a lodger or a tenant. And you must be in need of long-term care. And that means that you must have an injury or illness, and that could be physical or mental, which is likely to require care for more than 3 months. Or you must be disabled as defined under the Equality Act, or it must be a care reason connected with old age. So again, what the take-up will be, one doesn't know. It is unpaid leave, but it is this extra 5 days, which is available to people with caring responsibilities.
That's good to know, isn't it?
Yeah, I think if you remember, since 2002, there's been a right to take emergency time off to care for the dependent. So if you have a child's taken ill at school, or a parent who falls down the stairs or something like that, you can take a reasonable period of time off and the idea is it's not to provide long-term care, it's to sort out arrangements, take someone to hospital, someone to look after the child, whatever it happens to be. I can see this 5 days unpaid carers leave being used by people if they want to have a longer period than just the initial 24, 48 hours after an accident, or discovering your child's got chicken pox or whatever it happens to be.
Yeah, absolutely.
Now, flexible working, again, this was flagged up at some length, but what has happened since the 6th of April is that the right to request flexible working has been amended. To begin with, it's a day one right. In other words, on the very first day of employment, you have a right to request flexible working, whereas prior to April, you had to have 6 months employment before you could make a request under the statutory regime. Other changes, it used to be prior to April that the employer had 3 months in which to reach a decision. That has been reduced to 2 months. And it used to be that you could only make one formal request for flexible working in a 12-month period, and you can now make 2 requests in a 12-month period. And I think that's a reflection of working life having changed post-COVID, where I think the government recognises that often working arrangements are much more fluid, much more liable to change. And therefore, there is this right to make 2 formal requests in any 12-month period. The 8 business reasons for rejecting a request, things like cost, impact on service, disruption, etc., they remain as they were before the 6th of April. So nothing's changed in that regard. There is now an updated ACAS Code of Practice, which has been published in support of the right to request. And I think one other significant change is this. You can't now, as an employer, just reject a request outright. You are meant to sit down and sort of consult with the employee making the request. And if you can't actually accept what they are asking for, the onus is on the employer to come up with a counter proposal, if you like, some sort of a compromise that might be possible. So I think in reality, if there is still a good business reason for saying no, then I think the employer will be fine. But
Yeah.
clearly, the onus is really on the employer now to properly consult with the employee. And I think, as always with these things, a lot of it is about being proactive.
Yeah.
Periodically auditing your workforce. How many people already have flexible working? What capacity do you have to accommodate future requests for flexible working? So that when one is made, you're in a better position as the employer to make a sort of well-informed decision.
Yeah, and it's that extra onus on employers, isn't it, to have to consult with around other options. That you're right. That's a completely different and new change, and it is more onerous. So yeah, that's absolutely the right advice for people to be a bit more proactive with it behind the scenes if they can be.
Yeah, and I think there's still a bit of a temptation, a sort of a knee-jerk. Well, if I give you flexible working, I've got to give someone else flexible working. And I think
Yes.
what the law is saying is, look, move away from that very defensive approach to a much more proactive approach. Because if you can find a compromise, you're much more likely to have a productive, happy worker than if you've got someone who carries on working under sufferance, or indeed actually decides they've got to go somewhere else in order to get the pattern of work that they want. Bearing in mind, there are still 900,000 unfilled jobs in the UK. I guess just to finish, Rebecca, I ought to mention some other things, either that happened on the 6th of April or are in the offing. One is the annual increase to employment tribunal compensation limits. I think for an unfair dismissal award now, the maximum compensatory award will increase from just over £105,000 to just over £115,000. And the limit on a week's pay increases from £643 to £700. I mean, what that means is that the minimum basic award for things like breaches of health and safety will go up to just over £8,500. And, even if there's no discrimination involved, the fact that someone now could potentially win over £100,000 in compensation, remembering, of course, it's the lower of that or their annual pay, I mean, that is quite significant. I think linked to that, the injury to feelings awards that you can get in the event of a finding of discrimination have increased. If you remember, there are 3 bands depending upon the severity of the act of discrimination. And it used to start at £1,200, and it used to go up to 56,200. And in fact, now those injury to feelings awards will start at £11,700 and go up to £58,700 for the really most extreme forms of discrimination. So again, remember that those are additional awards. They're not dependent upon a loss of money. They're not compensatory. They are an award for injury to feelings. And that's quite a significant sum of money if the tribunal felt that an employer, for example, had acted very maliciously in a predetermined way, and so on and so forth. Other things coming in, and going back to family-related law, in April 2025, we can expect the introduction of neonatal care and leave. The idea there is that if you have a child under 28 days old that needs hospitalization for 7 days or more, however long your child spends in hospital will be added on to your maternity or adoption or shared parental leave up to 12 weeks. So if you had a child who was in an incubator for 5 weeks, what the neonatal care law will say is that if you're a mum taking maternity leave, well, your 52 weeks maternity leave will have an additional 5 weeks added on at the end to reflect the period of time that the child spent in hospital. So that's something that's coming in a year from now. A couple of things finally, just to flag up for the summer and September. This summer, we're going to get a new code of practice around dismissal and re-engagement. That's really prompted by the P&O Ferry saga 2 or 3 years ago, where they just basically sacked everybody and paid them the punitive damages because it was, still worked out a lot cheaper for P&O ferries in the long term. And essentially, what it did, it brought into focus the whole fire and rehire ethos. The idea that if I want to ultimately force through a contractual change, my ultimate option is to serve notice to terminate the current employment contract and then offer to re-engage someone on the new terms and conditions. The government have not outlawed fire and rehire. What you've got with the dismissal and re-engagement code of practice is about 14 pages extolling employers not to do it, but then at the end saying, well, actually, if you must do it, then this is what you'd expect to do by way of notification and so on and so forth. So, I think in truth, that goes some way short of what Labour have promised to do if they come to power. I think I'll stop there because I think that really covers the main things that are on the horizon. But I hope that's been a helpful summary of what's going on.
Yeah, absolutely. And there's loads going on this year, isn't there? Having, as we've already heard, and what's also coming up for the remainder of the year. So yeah, absolutely. We'll keep an ear out, everybody, for the other employment law updates by subscribing to the podcast. It's the Employment Law Insights podcast. But if you do need any assistance at all with anything either within this podcast or employment law related, then please either contact myself, rebecca.kearney@watemans.com, or Mark on mark.landon@watemans.com. And thanks again, Mark, for providing us with that helpful summary of updates that have been implemented and are upcoming.
Okay, that's a pleasure.
Okay, and thanks everybody for listening.